and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Daniel B. Rice, an associate at the Georgetown University Law Center Institute for Constitutional Advocacy and Protection. We will discuss his article, Non-Enforcement by Accretion, the Logan Act and the Take Care Clause, which is published in the Harvard Journal on Legislation. So welcome to the show, Daniel.
Thanks so much for having me, Brian.
Yes, I know. This is all my pleasure. I want to say the article is like super timely because the Logan Act has been in the air in the last, 3 years or so. But reading your paper, I realized it's like perennially timely because it seems like the Logan Act has been on one person or another's lips for like the last 200 years or something, 200 plus years. So it's kind of amazing. And it was a fun read as well as being a really kind of provocative way of thinking about kind of the structure of the executive and the nature of executive responsibility. But I wonder if you could start by just kind of explaining for listeners who may not be, highly active on Twitter at the moment, exactly what the Logan Act is, sort of when and why was it enacted and what was it intended to do?
Sure. So the Logan Act is a 220-year-old federal criminal statute that has amazingly served as the basis for exactly 0 prosecutions over the course of American history. So it was enacted in 1799 after a Philadelphia Quaker and physician named George Logan sailed to Paris at the height of an undeclared naval war between the United States and France. He thought he could smooth over relations in a way that the Adams administration had proved incapable of doing. So when Logan returned to Philadelphia, which was then the nation's capital, Federalists in Congress and in the administration were absolutely furious at him. They thought he had, blatantly usurped the executive prerogative to conduct diplomacy on behalf of the United States, and they thought there should be some criminal consequences for doing that. So in relatively short order, Congress passed what history has come to know as the Logan Act. And this is a pretty gross oversimplification, but in brief, what the Logan Act does is criminalize certain unauthorized efforts to interfere with American foreign policy through direct communication with foreign governmental officials. It doesn't purport to prohibit any conversations with foreign governmental officials, but only ones with a relatively narrow domain, as confined by the mens rea of the statute, right? So pretty remarkably, just to repeat what I said earlier, because it's so striking, there have been no prosecutions under this act for 220 years, right? So there have been only 2 indictments. The first was in 1803 and the second was in 1852. Neither one of those indictments, though, was pursued past the initial phase.
So it's kind of a contemporary of like the Alien and Sedition Acts, right? But like for some reason they got reversed or they got taken out, but the Logan Act kind of just stayed in the U.S. Code.
That's exactly right. So the Alien and Sedition Acts, my understanding is they contain sunset provisions that meant they automatically expired at the end of, I think it was a 2-year period. But the Logan Act, for whatever reason, probably because the Federalists were so, incensed at what George Logan had done, did not contain a similar sunset provision. So the act remains on the books until it's repealed, and that moment hasn't arrived just yet.
So maybe you could talk a little bit about those 2 initial indictments that were never pursued, because it's kind of interesting to think about like why the indictment would have been filed and sort of why it wasn't pursued. And then also, as I understood it from your paper, one of the 2 was actually sort of had been forgotten.
Yeah, that's right. So the first indictment occurred in 1803. A man named Francis Flournoy, I think I'm pronouncing that right, a Kentuckian, had written a letter in a newspaper proposing that parts of the western United States secede from the United States proper and ally themselves with part of what was then French territory in North America. That letter, the purpose behind that letter became mooted as the United States acquired much of what is today the western, or I guess central United States with the Louisiana Purchase. So that indictment had no legs after after that occurrence happened. And the second occurrence was in 1852. So a man named Jonas Levy wrote a letter to the president of Mexico in an effort to, I think this was in relation to a proposed treaty between Mexico and the United States about who would have certain rights to build a railroad across either a peninsula or an isthmus in Mexico. I'm not sure which. But what fascinates me about this particular incident is that, as you said, everyone seems to have completely forgotten about it. For all Logan Act commentary and articles that mentioned the act, from the beginning until my piece, it seems that there was only one indictment. That occurred in 1803. If you just Google the Logan Act and read any news article before 2017 or 2018, there will be repeated assertions that only one indictment has occurred, and through the use of some unconventional search terms, I found that, in fact, Jonas Levy was indicted in 1802 at the behest of Secretary of State Daniel Webster. And my understanding is that indictment wasn't pursued because Levy's lawyers challenged the Secretary of State to produce the actual letter that Jonas Levy had written to the president of Mexico, and more particularly the basis for the indictment. And unsurprisingly, the president of Mexico was unwilling to furnish that correspondence to the American government.
Oh my. Oh, that's a great story. Yeah. Wow. So why is this that there were so few indictments and really no prosecutions at all? I mean, is it because people just didn't think there was there was never a violation, or no one ever called for it, or what happened? Like, why hasn't this ever been pursued?
Yeah, that's the $1,000,000 question. And the reason I think that it's such a good question, and that the absence of prosecution is such a bizarre phenomenon, is because this statute was enacted to reinforce the president's constitutional authority to conduct diplomacy on behalf of the United States. As I say in the article, this is arguably the most pro-presidential statute in all of American history. If there's a more executive-friendly enactment, I'm not aware of one. So in the paper, I go through, after having organized my research notes, to try to provide some transparency for these non-enforcement decisions. So when the executive in the past has failed to enforce the act, those individual decisions are almost never accompanied by clear statements for the reasons for declining a particular prosecution. So what I did in my research was try to reconstruct those decisions to provide some accountability for these non-enforcement choices. And the second main reason why I wanted to go ahead and do this was if non-enforcement of the Logan Act was motivated by constitutional concerns, then arguably that's perfectly fine under the Take Care Clause. There's, I think, a general consensus that good faith constitutional objections can be a reason not to enforce a federal statute. So what I found was that non-enforcement of the act has almost never been accompanied by an open assertion of unconstitutionality. In fact, the clearest statement to that effect I found was from a single anonymous attorney in the State Department Legal Advisor's Office, who said to a newspaper reporter in 1972 that attorneys in that office had long viewed the act as so vague as to be unenforceable. But I found nothing to corroborate that assertion as actually influencing the executive's enforcement decisions in any other context. So to get back to your question, though, I'll sort of tick through these reasons as quickly as I can, and then I'd be happy to return to any of them if you'd like. So I've 12 reasons why I think the act has gone unenforced. These are overlapping in certain respects. I'm not claiming that they're totally comprehensive, but I think this sort of battery of explanations does a lot of explanatory work. So first, some violations, surely didn't harm the executive of the nation enough to warrant enforcement. And I think maybe related to that is the fact that, prosecuting anyone under a federal criminal statute sends the message that that person has harmed the national interest enough to warrant a deprivation of liberty. And with respect to people who are just these minor meddlers who sort of monkey around on their frolics overseas, prosecuting them would send the message that the executive felt that its interests were gravely harmed by what they did. And not prosecuting them can actually be a signal of strength in those situations, interestingly. Reason number two is that prosecuting anyone would almost certainly amplify their viewpoints and transform them into martyrs, which is something the executive, after it has been frustrated in that way, might not be eager to do. And the third reason that I've identified is that perhaps the only people who are capable of inflicting the kind of harm that would warrant a prosecution they tend to be very famous. So like members of Congress, celebrities, movie stars, people like that. And I could understand why administrations might be a little hesitant to prosecute the Henry Fords and the Jane of the world, right? So reason four is a lot of potential Logan Act violators have been presidential candidates. So Richard Nixon literally conspired with the South Vietnamese government to undermine his opponent, Hubert Humphrey, in the 1968 election. Like, that was a clear-cut violation of the Logan Act, and President Johnson knew about it at the time, called it treason in confidence with his advisors. But you can understand why he might not want to prosecute the opposing party's presidential candidate. The fifth reason that I've identified is that a lot of Logan Act violations are in service of doing highly humanitarian things, right? So a lot of Logan Act violators, or Loganeers, as I affectionately call them in my paper, are trying to reduce starvation. They're trying to avert genocide. They want there not to be nuclear war, right? So just imagine the outcry that would result if people like that are, sent to a federal penitentiary for up to 3 years. The sixth reason that I identify, I'm sorry this is so long, but it's hard to among my babies here. The sixth reason I identify is that a lot of key members of administrations almost certainly violated the Logan Act themselves before taking office. And if there were a culture of aggressive Logan Act enforcement, their own behavior before taking office would become subject to, if not official investigations, the kind of scrutiny that would be a major distraction and that they wouldn't want to have. The seventh reason is that a lot of presidents and secretaries of state, attorneys general, understand that they need something to do after their administrations expire. And it's kind of fun to stay in contact with your overseas interlocutors, and that has manifested occasionally in presidents, or I guess ex-presidents, continuing to be self-appointed diplomats and to try to resolve some diplomatic crises that have befallen the nation after their periods of service have ended. So I don't actually know if administrations have enough foresight to be thinking about this prospectively, like while they're still in office. But I can at least imagine why they might be hesitant to enforce the act if it would hamstring their post-presidential activity. Right. The eighth reason is that lots of potential Logan Act violators would be members of a president's own party. And it could be deeply uncomfortable to prosecute their political allies in that way. And many Logan Act violators have also had personal relationships with the presidents or the attorney general and the like. So prosecuting those sorts of people could be deeply uncomfortable. The ninth reason, and the one that I think may actually have the most explanatory purchase, is that the executive branch often needs private citizens to solve problems that official intergovernmental relations just can't, right? So there have been times throughout history when relations with other nations have broken down and where we're like almost at war, but it would just be devastating if war were to result. And so in those sorts of situations, like the Cuban Missile Crisis, right? And in those sorts of situations, administrations need someone who isn't publicly aligned and identified with the administration to talk to these pariah regimes, to try to smooth things over through back channels. And they need to be close enough to the administration to project an ability to bind the administration in these sorts of secret deals, but distant enough so that they're not identified with the regime that is that refuses to maintain relations with these our foreign counterparts. And the interesting thing about this, and the reason why enforcing the Logan Act would make these sorts of back-channel negotiations almost impossible, is that if we had a culture of routine enforcement of the act, anytime a president sort of privately deputized someone to solve these crises in a sort of private way, reporters would have just a massive incentive to identify the exact level of authorization that an administration had bestowed on these sort of private go-betweens. that the administrations had chosen. And so that would gravely frustrate president's ability to solve international crises in that sort of way. So on to the ninth reason. I'm sorry, I guess I'm on number 10 now. This is one of my absolute favorites. So a lot of major foreign policy triumphs throughout American history were arguably done in violation of the Logan Act, right? And enforcing the act after these sort of grand triumphal moments would it would be not only deeply uncomfortable, but just it would seem really, really unfair to prosecute people who say acquire, 525,000 square miles of territory in the Treaty of Guadalupe Hidalgo, or who saved, hundreds of lives in, prisoner of war exchanges and things like that. So the 11th reason that I identify is that Logan Act violations often occur in privacy, where it's like only the violator and the particular foreign official who is the subject of the conversation. So there are evidentiary difficulties in enforcing the act. Just imagine like trying to call like the emperor of some country or the foreign minister of some country to testify in an American court. I'm not sure how that would happen procedurally. Even if it did, who knows like what could happen if they actually got in court and testified. So the hesitancy to risk any of that could be a reason why the act goes unenforced. And then finally, and the 12th reason I identify is that non-enforcement of the act is sticky, right? The very historical practice of non-enforcement is self-perpetuating. I've identified a number of reasons in the paper, a number of instances in which administrations, when asked, why they're not enforcing the Logan Act, have said, well, no one's ever enforced it before. This act was never got enforced. And basically, why should we be the first ones to do it here? So the Logan Act has taken on a certain use it or lose it quality. And it's my contention that we have decidedly lost it, right? The Logan Act is no longer regarded as a law of the United States whose enforcement is constitutionally required. It's the source of much mockery. And as you mentioned on Twitter, whenever plausible Logan Act incidents occur, people say, oh, it's never the Logan Act, right? The Logan Act can't be used here. And administrations have felt that sort of imperative and sort of internalized that inability to actually use the statute for its intended purpose. And I'll stop there, mercifully.
Right. So, with a dozen reasons not to use the Logan Act, I guess it comes as no surprise that it never seems to be the right solution to whatever particular problem seems to arise. But in the paper, you suggest that there's still a problem there, and you tie that to what you call the take care clause. So maybe you could talk about what that is and what it does and why you think it's relevant under these circumstances.
Absolutely. So the take care clause of Article 2 obligates the executive branch to, quote, take care that the laws be faithfully executed, right? At the most basic level, what that requires is that Congress enjoy policymaking primacy within the federal system, right? So the executive branch can't entirely refuse to enforce a federal statute because that particular statute is believed to embody poor policy, right? Congress gets to set the policy judgment. Congress makes the policy judgments on behalf of the United States, and the executive enforces that will, as expressed through the bicameralism and presentment process, right? So in the past decade, there's been sort of a spate of really fascinating take care clause articles written, I think, largely in response to some of President Obama's key non-enforcement initiatives. Here I'm thinking in particular of DACA and DAPA, which are highly relevant for other reasons now. And with those particular memoranda, President Obama was articulating openly the ways in which his administration would use their prosecutorial discretion, given the reality that not literally everyone who violates the immigration laws, can be deported, right? So through DAPA and DACA, President Obama sought to sort of explain to the world how his sort of line level enforcers would use their enforcement discretion. Some of the scholars that I mentioned think that this violates the take care clause because, in their view, this effectively licenses, unlawful behavior on a prospective basis. It effectively, in their view, greenlights violations of federal law in a way that the executive just doesn't have the authority to do because the executive is supposed to enforce the law. Other scholars disagree and think that there is great virtue in being transparent about the way in which administrations are exercising their prosecutorial discretion. I don't take a definitive view on that particular constitutional debate. But what I want to do is unsettle the assumed distinction between case-by-case non-enforcement and programmatic and deliberate non-enforcement, right? So basically everyone assumes that prosecutorial discretion is perfectly compatible with the take care clause. The thought is that administrations don't need to prosecute literally everyone who violates a law. Not all violations are equally reprehensible. Resources often won't allow for full prosecution. So the reality is that, some people who commit federal crimes just, go free. They don't actually have to serve any prison time. So the Logan Act is an interesting example here because, in my view, the repeated use of individualized enforcement discretion over a very long period of time, i.e. 220 years, has led to a state in which, as I mentioned earlier, the Logan Act just is no longer regarded as federal law or enforceable federal law. Like the past practice in an entirely episodic and sort of incremental and reactive basis rather than a deliberate and programmatic basis has stripped the Logan Act of any remaining vitality, such that the thought of enforcing it is a total non-starter. In my view, that is a blatant separation of powers problem. It distorts the assumption that Congress is supposed to set policy. The president is supposed to execute that policy. And it arguably violates the take care clause as well. Because I think the clause imposes a generation-spanning obligation on the executive as an institution to ensure that particular statutes are enforced. And that just hasn't happened with the Logan Act.
Okay. So if I understand you correctly, then there's like a debate over whether the executive is constitutionally authorized to simply say, I'm not going to enforce this legislation as written at all because I think it's bad legislation. And then there's not so much there, or maybe even no debate over whether the executive has discretion, whether or not to prosecute particular cases. And you think that the Logan Act kind of fits in sort of to a different place here. I'm wondering, are there other reasons the executive might legitimately or potentially illegitimately refuse to implement particular congressional legislation?
The reasons that I think would be legitimate would be if they felt that there was a constitutional problem with enforcement of the act, especially if that putative constitutional problem were to trench on the executive's on executive authority. For example, the president's ability to, say, conduct foreign relations. I also think it would be perfectly legitimate in individualized cases to decline to enforce particular law because of evidentiary concerns. The weird thing is with what I'm calling non-enforcement by accretion or incremental non-enforcement, it's hard to offer any sort of account of reasons for non-enforcement that would be legitimate because it's really awkward even to begin aggregating, the reasons for non-enforcement. It like almost makes no conceptual sense to ask whether, failing to enforce the Logan Act for non-constitutional reasons is constitutionally permissible across the range of outcomes because there have been like an infinitude of reasons given or not given. And what I'm trying to do in this paper is to, negate constitutional concerns as an explanation for non-enforcement because I just don't think that those actually have been the reason why presidents have declined to enforce the act. And in fact, if it were the reason, there is a congressionally prescribed mechanism for informing Congress of those sorts of constitutional concerns through a statute at 28 U.S.C. 530D, which has been used time and again since the 1970s. Right. So once the constitutional basis for non-enforcement has been removed, it's a possible explanation. There's lots and lots of other stuff that could be motivating non-enforcement of the act. And I think just whatever the reasons are, especially since administrations across the decades have utterly eschewed any efforts at transparency and enforcement, they routinely say things like, no comments, I don't want to get into that, this subject makes me deeply uncomfortable. It seems to me that utter failure to enforce the act across a range of circumstances, coupled with a failure to offer any sort of constitutionally grounded or otherwise persuasive reason for failing to enforce the act, it gives rise to a separation of powers problem and a take care clause problem.
Yeah, I mean, it seems like the dozen reasons you elaborate or enumerate, as well as all the kind of like subsidiary related reasons, create a situation that's so different from what President Obama, for example, found himself in with DACA and DAPA, where it was like he could cleanly articulate what he saw as being the policy problem and the specific rationale why he wasn't going to pursue it. But in the case of the Logan Act, it's so messy from the executive perspective. I mean, there's like practical incentives and pragmatic incentives and, you know, circumstantial incentives not to pursue, not to explain why it's not being pursued, that the executive just isn't in a position to do it. I mean, if the executive can't kind of state those kinds of rationales, who can?
I mean, it's funny that you ask that, because the particular executive actors that are often asked, why aren't you enforcing this act? It appears that someone has violated the law. It appears that enforcement is called for. What they typically do is say, that's a question for the Department of State. And then the Department of State will say, that's a question for the Justice Department. It's not obvious whether any other actor in the federal system has any responsibility to account for the executive's failure to enforce the act. And, I'm hoping that, my paper will, shine a light on the failure to offer explanations and will actually offer some insight into the various reasons for failing to enforce the act. I just want to make one additional quick point on this. I guess as an asterisk to what I said earlier, that non-enforcement of the Logan Act is undemocratic in a sense because Congress gets to set policy, right? There's also sort of a strange sense in which the complete non-enforcement of a federal statute over a very long period of time in an incremental way have maybe an even greater democratic pedigree than a statute enacted at a particular moment in time long ago, right? So what we have here is lots and lots of administrations, that were elected at discrete moments in time, individually refraining from bringing enforcement actions against people, right? And they were elected by the whole country. And it's as if we as a polity have just determined that, certain actions do not, in fact, merit the sanctions that Congress has prescribed for them. So, query whether the legislative policymaking supremacy justification for enforcement actually, has purchase here.
Yeah, I mean, I wonder if you could talk about the constitutional question really briefly as well. Because I agree with you that, I think you've shown pretty conclusively that, there's a mechanism for the executive to raise constitutional concerns, and that mechanism simply has not been used. But I can't help but wonder if, like, the same kinds of structural incentive problems that prevent the executive from objecting on policy grounds to the Logan Act also apply to the executive raising constitutional objections. I mean, do you think there are constitutional objections that could legitimately be raised? And are there aspects of the Logan Act that could survive them?
Yeah, that's a great question. So a lot of commentators, whenever these Logan Act incidents arise, sort of reflexively say, this very old statute is, it's outmoded, it's archaic, it's stupid, it's a museum piece, and it would obviously fail if a First Amendment challenge or a vagueness challenge were brought. I'm actually pretty skeptical of those sort of pat assertions. I think those questions, if they actually made their way to the Supreme Court, would probably divide the court. So I'll say, just as a preface to this, it's not obvious to me. So I'll start with the vagueness point. So it's not obvious to me that analysis, that vagueness analysis, would be undertaken in the ordinary, like, statutory interpretation sense. So it seems to me that certain of the Act's terms, and I didn't recite the entire statute because it's quite long and your listeners would fall asleep. But certain of the Act's terms, like which types of entities qualify as foreign governments or their officers or agents, or which types of international disagreements arise to the level of a dispute or controversy with the United States, it seems to me that the executive's factual determinations on those questions might actually have to be taken as conclusive by a court. And I'm building off of a wonderful article that Tara Grove wrote in 2015 called "The Lost History of the Political Question Doctrine." I think the proper interpretation, or just the interpretation of this statute, might actually require, if it were presented to a court might have to defer to the representations made by the executive branch in those respects. I'm not certain on that. So, let's assume that ordinary vagueness analysis would apply, right? So the two key questions that vagueness doctrine is designed to address are assuring that regulated parties have notice of what a statute prohibits, and in making sure that statutes aren't written so amorphously that the enforcers have untrammeled discretion to enforce them in arbitrary and discriminatory manners. So what's so bizarre about this is that it's the complete failure to enforce the Logan Act that gives rise to fair notice. Everyone understands that violating the law has no criminal consequences, and prosecuting anyone under the act would be just the height of unfair notice. And prosecuting anyone would be just almost the definition of arbitrary enforcement, because no one would have been prosecuted in analogous circumstances in the past. Unfortunately, it's not clear to me that there's any foothold in vagueness doctrine for those sorts of practical concerns to come into play, to bring the history of non-enforcement into that. So the question then becomes, is the text of the act worded so capaciously that people don't have fair notice, and such that there's a structural likelihood of arbitrary and discriminatory enforcement? That's a really complicated question. It would have a lot of strands to untangle, because there's a lot of verbiage that would be an issue. But I would just point readers to this great lawfare piece from 2017 by Daniel Himmel and Eric Posner on hypothesizing potential limiting constructions in the event that a vagueness challenge was brought to the Logan Act. I don't think I'd agree with every single one of their specific conclusions, but I think the premise of their piece is right, that courts would be inclined to try. They're generally inclined to try to salvage federal legislation if a principled limiting construction can be supplied. And I think there's a very good chance that either that would happen, or in the instances in which it wouldn't be obvious what the limiting construction was, a court might just have to defer to the executive's representation for the reasons that I spelled out earlier. Moving on, just very briefly to the First Amendment question, if I may. So it's not clear to me that the First Amendment actually protects the kind of speech that the Logan Act regulates. So in a 2010 case called United States versus Stevens, the court laid out a methodology for determining which kinds of expression actually, as a threshold matter, enjoy or constitute, quote, the freedom of speech. And with the Logan Act, there is a very long history of regulation here, which is one touchstone for categories of expression that may not enjoy First Amendment protection. Maybe that lengthy history of regulation doesn't count because it's been accompanied by an equally long history of non-enforcement, and maybe it doesn't count because of its close temporal association with the reviled Alien and Sedition Acts. But I just wanted to raise the possibility that the speech regulated by the Logan Act might not enjoy First Amendment protection at all. So assuming the First Amendment is implicated as a threshold matter, the act definitely would amount to a content-based restriction on speech. If you speak with foreign governmental officials about yesterday's World Cup game, that's definitely not prohibited. But if you speak to them in a way that's designed to influence the measures or conduct of that government in relation to disputes or controversies with the United States, or to defeat the measures of the United States, that's a felony. Right. So it's definitely a content-based restriction on speech, such that the act would have to satisfy strict scrutiny. And the question there is whether the act serves a compelling governmental interest, and whether the act is the least restrictive means of advancing that compelling governmental interest. I think there's a very good chance the court would conclude that a compelling governmental interest does underlie the Logan Act. I mean, we're not talking about just ordinary speech here. This is speech conveyed directly to a foreign sovereign on matters as to which there is presently a dispute or controversy between that country and the United States, or in a way designed to defeat the measures of the United States. Right, that's some pretty serious stuff. On the tailoring question, whether the act is the least restrictive means of advancing whatever the government's interest is, I think that's where it kind of gets tricky. And I guess it would depend on the level of generality in which you defined the government's interest. But I think it would be ironic, actually, if the act failed First Amendment scrutiny because it was too under-inclusive, right? So if your principle is private citizens shouldn't be able to subvert the executive's foreign policy objectives, the Logan Act does not advance that interest as fully as it could, because it doesn't cover all matters in which the executive has a foreign policy interest. Disputes or controversies between just any two nations that haven't yet ripened into a dispute or controversy with the United States, people can talk to those governments about their things all day, assuming the executive position on those things doesn't rise to the level of a measure of the United States. So, sorry, those were so long, but the short answer on those is it's really difficult to know whether the act survives scrutiny.
So, it seems to me then the deep, intractable in some ways question here is, if the Logan Act is at least, let's assume, like partially enforceable to a greater or lesser degree, but the executive just clearly, historically, and practically doesn't want to enforce it, but for structural reasons can't functionally explain why it doesn't want to enforce it. Like, what should happen? Who should do something? Why should they do it? And what should they do?
Answering this question, it reminds me of the question that the moderators proposed to the Democratic candidates the other night. If you're president and Mitch McConnell is still Senate Majority Leader, what are you going to do? There's just no good answer here, right? Because we're in this weird sort of pathological stalemate where Congress has passed a law, the executive has refused to enforce it, such that it has become practically unenforceable. And because no prosecution is likely to result, there's no like catalyzing event. There's no stimulus to sort of induce Congress to get off its butt and act. And that's part of the reason why no repeal legislation has happened, or at any point over the past 220 years. So the possible candidates for excising the Logan Act from the U.S. Code are very few. One of them would be just any time Congress undertakes a general revision of the federal criminal code, maybe just sneak Logan Act repeal in there somewhere. And this was actually tried in 1978, but a single U.S. senator from Mississippi, James Allen, noticed the omission and said, no, the Logan Act, needs to continue to exist because we don't want to send the message that it's okay to go abroad and undermine the president in foreign policy matters. And Ted Kennedy, the leading champion of Logan Act repeal, just sort of caved as a way of avoiding a filibuster. Another option would be either a freestanding repeal bill, which I think is very unlikely for the reasons I already gave, or just in any other legislation, just hiding, a repeal measure, just tacked on to some other piece of legislation. I think that would be like a highly untransparent and deeply undemocratic thing to do, but I would probably support it because I just don't know what other way of getting rid of the Logan Act that there might be. And I certainly don't want it to happen through a prosecution, because given the very lengthy history of non-enforcement, I just think it would be hugely unfair to the first person who is prosecuted, given that, just countless people in similar circumstances wouldn't have felt those same consequences. And just to tag on one thing, a thought that just occurred to me is that not 2 months ago, President Trump stood before cameras and said that John Kerry has violated the Logan Act. He said that 3 times, and quote, he ought to be prosecuted. So I guess just as a supplement to what I just said, it's at least conceivable that John Kerry would have standing to sue for injunctive relief. If he believes that the Logan Act is unconstitutional. But that's the only time in American history, as far as I'm aware, that a sitting president has accused someone of violating the Logan Act. So this would seem to be a unique situation for standing if there ever were to be such a case.
Oh my. Okay. So, in closing, Daniel, what I took away from your paper was that there are these profound incentives, deep-rooted incentives for the executive not to pursue Logan Act prosecutions. Now, of course, President Trump may very well be the exception to that, as he seems to be the exception in so many other ways. And perhaps he will be the first to bust right through all of those structural incentives and really bite the bullet. But it also seems like there are a lot of incentives for Congress not to want to act as well. I mean, and it seems like the presence of the Logan Act is rhetorically valuable for Congress as well. I mean, what's the likelihood? What's the reasonable likelihood of anything happening here? And if there just is this kind of structural gridlock that prevents fixing this problem, should we worry about that? Should that be like a sign for future Congresses to or something that they should think about when passing legislation? I mean, let's avoid another Logan Act problem, as it were. I mean, what should we learn from this?
Yeah, so on the first question, I think it is extremely unlikely that anything will happen anytime soon concerning an amendment or repeal of the Logan Act. So aside from just the fact that I think an actual prosecution would probably be necessary for legislative action to take place in this arena, there are, as you mentioned, real structural incentives to do nothing, right? So the Logan Act, although it is no longer regarded by and large as an enforceable law of the United States, it still functions as sort of a powerful stand-in for this idea that there's one president at a time, and people shouldn't be going around and thwarting the executive branch's foreign policy. So the continued existence of the Logan Act enables the president's critics in Congress and in society more generally to accuse certain people of lawbreaking. Right? It takes this norm that in the absence of the Logan Act would have to be justified on other grounds, and channels it into this rhetoric of criminality. So I think there is actually an interest group that has a deep interest in the Logan Act continuing to exist, and it doesn't cut in any particular partisan direction. So at any particular moment, it seems half of Congress, or a little more than half, will have a vested interest in the Logan Act continuing to exist, and half will, think otherwise. So I come out of this experience deeply pessimistic that there's an easy way to resolve this weird interbranch stalemate. And that allows me to transition into answering your second question, which is what can Congress do in the future, if anything, to make sure that this doesn't happen? I suppose that if they wanted, they could include in their legislation expectations about the level of enforcement, or even to obligate the president to enforce a particular statute at certain levels. I mean, that would be part of the statute that the executive, had a constitutional duty to execute. Right. But they didn't do that with the Logan Act. But they did. The Senate, in fact, did do maybe the next best thing, which was in 1980 when former Attorney General Ramsey Clark and some others went to Tehran at the height of the Iranian hostage crisis to try to get the prisoners released. The Senate passed by voice vote a resolution that the Logan Act be enforced in the face of these ostensible violations. The Carter administration, unsurprisingly, did nothing. But it's like we're in Youngstown Box 3 territory here. So Congress is constitutionally entitled to have its laws enforced. It continues to say, we want our laws enforced, and the executive is acting directly contrary to a continued congressional preference. So that may be something that I visit in future work. How can Congress, if it doesn't do something at the front end like that, are there ways of signaling its preferred level of law execution? Are there ways of getting Congress involved in the proper calibration of enforcement in ways that don't actually violate the separation of powers? Because, of course, Congress can't formally involve itself in law execution. A number of Supreme Court cases make that clear. So, yeah, I have no good answer to your question. I'm not sure what we do from here, and it's not entirely clear how to solve the problem in the future.
Well, that's wonderful for your future scholarship, and I look forward to reading follow-up papers in the same subject, because I really enjoyed this one very much, and I enjoyed talking to you about it as well, Daniel.
Yeah, thanks for those kind words, and it was a lot of fun being on this program. Thank you.
Kopfschmerzen und ich fühle mich nicht wohl. Ich habe Magenschmerzen und der Knochen ist verfault. Ich möchte ein Glas kalter Milch, wo ist das Krankenhaus? Sie müssen im Bett bleiben. gesagt. Nein, er hat Unrecht. Nein, 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 er hat Recht. Man hat mich bestohlen, bewegen Sie sich nicht. Und es gibt zu viel Wasser im Boot. Ich will $10 wechseln, dieser Bütter ist nicht Fisch. Ich habe einen Führerschein, ich esse keinen Fisch. Verkaufen Sie ein Hut geschafft, verkaufen Sie dazu. Mein Pustenhalter ist zu warm und der Wasserfall ist flug. Ich verstehe nicht alles, was haben Sie gesagt? Nein, er hat Unrecht. Nein, 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 er hat Recht. Man hat mich bestohlen, bewegen Sie sich nicht. Und es gibt zu viel Wasser im Boot.
Boom shakalaka laka.
Sehr gut,
Boom shakalaka laka.
sehr gut. Ich habe Schlimmkopfschmerzen und ich fühle mich nicht wohl. Ich habe Magenschmerzen und der Knochen ist verkohlt. Ich möchte ein Glas kalte Milch, wo ist das Krankenhaus? Sie müssen im Bett bleiben und wo ist der Fledermaus? Ich verstehe nicht alles, was haben Sie gesagt? Nein, er hat Unrecht. Nein, 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 er hat Recht. Man hat mich bestohlen, bewegen Sie sich nicht. Und es gibt zu viel Wasser im Boot.
Boom ba-dum.
Sehr gut,
Boom shakalaka laka.
sehr gut,
Boom ba-dum.
sehr gut,
Boom shakalaka laka.
sehr gut,
Boom ba-dum.
sehr gut,
Boom shakalaka laka.
sehr gut,
Boom ba-dum.
sehr gut,
Boom shakalaka laka.
sehr gut,
Boom ba-dum.
sehr gut.
Boom shakalaka.